don't know how much longer he's going to have counsel. What I can tell you is this: a finding that he is a vexatious litigant protects the court and protects Ms. from further frivolous filings, gives her that additional protection, and allows her to move on. Hopefully, at one point, she'll no longer need an attorney because we'll be done with these proceedings. Otherwise, Mr. demonstrated that he, will enjoy being a keyboard warrior and filing whatever he wants to file if the time suits him.
Oh, and then another one that comes to mind, just because I thought it was like, again, who thinks like this? Let me know where that old bitch's grave is so I can fertilize it regularly. Like, I don't even know what that means, but I know it's really disgusting.
We are on the record. This is Dee's. Appearances, please.
Good afternoon, Your Honor. James Jimmerson, bar number 12599, on behalf of the plaintiff, who's also on my right. Mr. Andrew Pastor from our office is also on Zoom.
Got it. Thank you.
Tim Treffinger, bar number 13877, on behalf of the defendant who's not present.
Thank you. And we have media here today. Sir, if you could just state your appearance on behalf of your organization.
Daniel Downs from our Nevada judges.
Thank you. Okay, so I do have the opportunity upstairs to read the brief that was filed. Mr. Jimmerson, did you have an opportunity to review it as well?
I read it after I got to the courthouse today, Judge, yes.
Okay, perfect. I literally just did as well. So we can start there. Please, you can be seated. I have to stand. Mr. Jimmerson, would you like to be heard on your brief that was filed a little while ago?
Yes, Your Honor. The court rightly recognized that this is an important issue, that the court must decide whether or not Mr. here is voluntary or not voluntary. And as the case law enunciates, whether it be the state Supreme Court here, state Supreme Courts elsewhere, or the federal court case law, they all support a finding that where the defendant in a criminal matter, because this is a contempt proceeding, so it straddles both the civil and criminal division. In a criminal matter, a party that is aware of the date of the trial, is aware of the time of the trial, is aware of the location of the trial, and yet does not show up, that by itself is sufficient for the court to make a finding that the absence was involuntary, especially in light of the Diaz versus United States decision, in which the Supreme Court had found that when a criminal defendant had appeared already at trial and then subsequently was absent, that it was permissible for the court to continue the trial in absentia, despite the fact that the defendant does have a right to appear at their own trial. Since the Diaz decision, which was 100 years ago, we have a litany of federal and state cases that all support that in this particular situation, where we have a defendant who's already shown up, who was certainly aware of the trial, and who has a history of trying to avoid trial, whether it be the first peremptory challenge on September 7th that was improper, whether it be the second peremptory challenge after this court issued an order to hold the October 11, 2024 date, followed by a improvidently filed affidavit or motion to seek this court's recusal that was denied by Chief Judge Weiss back in October of 2024, which unfortunately did result in the continuance of this evidentiary hearing from October 11 to yesterday, January 13, and today, January 14. We then see Mr. leaving the jurisdiction on December 14. We know this because we have the video images of him at Harry Reid Airport. I'm still getting used to the name change. We know that he's there. We know that he had said to his daughter on that morning of the 14th that he was traveling to Baltimore. We don't know if that's actually where he traveled. But we also know that wherever he went, that he was there consistently until, as at the latest time period, of January 5. And we know that because we have the same background in the video calls from talking parents. We also know that on January 5, he was not in Las Vegas because he asked his daughter, is it afternoon in Las Vegas? Which not only suggests that he's not in Las Vegas, but it suggests he may not even be in the country, because you would obviously know if you're in Baltimore, which is only 3 hours ahead, whether or not it's afternoon in Las Vegas. It suggests that he's likely out of the country, perhaps in Asia. As a result, Your Honor, when we have someone who is traveling, when we know is not in the jurisdiction, that we've tried to get a hold of him, whether it be Mr. Treffinger calling or emailing, whether it be the police department, who went and did a wellness check last night and didn't find any evidence of him being at his home, because not only did they not find his vehicle there was no items of furniture in the home, because the home is now up for sale. That decision to put the home up for sale happened, curiously enough, 12 days after this court had reset this hearing after he was unsuccessful in his effort to have this court recused from this matter. There is no evidence that he's in this jurisdiction. We have no evidence at all from anyone that would otherwise justify his absence from this courtroom yesterday. And in the face of the absence of evidence, when considering all of the other evidence that he isn't even in the jurisdiction, let alone attempted to get here, attempted to come to court on Monday afternoon, and for whatever reason there was some calamity that prevented him from doing so, that would be the suggestion, but there actually is no evidence of any such suggestion. The only evidence we have is that he was not in Las Vegas as of January 6th. He turned his phone off, or at least he turned his Talking Parents application off on January 6th in the morning. We know that, Judge, we believe it is exhibit, I think it is exhibit 5 on page 3, where the court will see that on January 6, 2025 at 6:04 a.m., Mr. enabled video calling consent from Talking Parents, and by extension, disabled Talking Parents' functionality altogether. As we see from the Talking Parents record, it states, this section contains a history of enabled or disabled calling consent for each parent. When a parent has calling consent disabled, they will not be able to place or receive calls through Talking Parents. So by revoking or withdrawing such consent, he has eliminated the functionality of Talking Parents, which by extension, Your Honor, eliminates his ability to talk to his own daughter. And what the court would also see from the record that we'd supplied the court concerning his statement that he was traveling to Baltimore was this concern that his daughter, when asking, are you going to Baltimore? His response wasn't, yes, I'm going to Baltimore. It was, well, that doesn't seem like a you question. It seems like a question from someone else, until eventually 5 or 6 lines later, he acknowledges, yes, I'm going to Baltimore. So what we see here is, Judge, a conscious effort to be unreachable. And the case law that we have supplied this court, specifically, I believe it was the U.S. versus Wilkinson decision, which identified the absence of, the failure to be able to reach someone by phone because it was turned off, is one of the facts that led the court to find that the absence of the defendant in a criminal matter was voluntary. So whether it be the history of this man trying to continue or avoid trial, whether it be his intentional withdrawal of consent so that it would disable the functionality of Talking Parents, whether it be the fact that his phone is now off or goes straight to voicemail, whatever it may be, this man knew that we were supposed to be in court yesterday at 1:30. He did not appear, and in the absence of any evidence to the contrary, the court should find that his absence was voluntary and allow this proceeding to continue. Moreover, Your Honor, I understand this court is concerned because there are obviously constitutional implications here. But there are a litany of decisions across the country that actually talk about the ability for the court to continue with the proceeding, in this case an evidentiary hearing, without perhaps knowing all of the facts, because you always have the right to seek a new trial, were there to be a motion filed later on, within the 28 days required under our rules. We certainly would be in a better position, or certainly Mr. to actually have a legitimate reason for not being here. He would have the ability to present such evidence in such a motion. We also, by the way, would have the ability to get additional discovery, Your Honor, in such an event. So the court is not without the remedies to unwind a decision to allow us to continue. We have set this time. The court is certainly not full of time. The court spends too much time on every case. The court is certainly not certainly without the hard work this court requires. And to allow this man to avoid this trial, to allow this man to effectively waste all of our time for 2 afternoons because he chooses not to show up, that cannot be countenanced. The court must allow us to continue. The court must find that his absence today is voluntary and that he's waived his right to be here.
Okay, thank you. Mr. Treffinger.
Thank you, Your Honor. I'm not going to dispute the case law, and I'm very familiar with the voluntary absence decisions. I dealt with it in the midst of a criminal trial as a prosecutor where a defendant tried to commit suicide on the day we arrested our case in chief, and I dealt with it in that context. There are some issues with this case in regard to the case law and how the facts are not quite the same. This hearing did commence previously. In fact, I believe he was on the stand when this hearing adjourned previously, and he would have been back on the stand had he been to court. I can relate to the court that I have not had any contact with Mr. Since Friday, at least direct contact. I did speak to him on the phone on Friday for, it was well over 90 minutes strategizing for these hearings. I will note that in sitting here now, I checked my case system. And this doesn't bear on a difference in anything aside from he did send me 3 messages bearing on strategy yesterday morning early in the morning at 5 or 6 a.m. That certainly seemed to indicate that he wanted to talk to me about things upon arriving here. So I was under the impression he was going to be here. The issue we have is, yes, there are ways to unwind what the court does in this case today. However, when you look at the number of contempt sanctions requested here, we're up over 600. And I'm not implying the court would sentence this way, but obviously the court could sentence to 48 years in the county jail if they were so inclined. And I'm not saying Your Honor is likely to do that because I think that would have its own implications on the system, but that exposure is there, and it's not something we can ignore. It's not as though he showed up for the first day of trial and then was gone. He was on the stand, he testified, he was in the middle of testifying. That testimony would not be finished if we just go forward today and get a decision. The issue here is, I'm not sure there's enough facts before the court to find that he's chosen not to be here. He hired counsel after he had issues with prior counsel. I'm not disputing the fact that he filed a motion to recuse that was denied, but he had the right to file that motion. Arguably, there were some issues with counsel at the time, and should there have been a certification of counsel that it was in good faith and not for the purpose of delay? Absolutely, that's what the rules say. However, he was having issues with counsel at the time, and Judge Weiss didn't decide to kick it for that purpose. He actually went through and gave us a decision on the motion. He didn't kick it because of that, did not find it was a delay tactic, didn't find it was frivolous, didn't find that it had merit enough to warrant recusal, but finding that something is not meritorious and something is frivolous are not the same thing. Unfortunately, yes, there have been delays in this case, and a delay would certainly give prejudice to the plaintiff, and I'm not going to sit here and say anything different. But when you're facing as many sanctions as they are asking for in this case, and I mean that's an issue we would have to get into pursuant to the evidence going forward anyway, the danger of prejudice to my client is severe, especially considering he seemed to be participating and working with counsel to work on this case up until yesterday morning at some point when all communication ceased. As I referenced in my email to the court this afternoon, this is a client I would put in the stack of clients that need additional care, because I don't think I've ever gone more than 3 to 4 business days without contact with my client. And I can tell you that I've never had a situation where his phone has been off and I have been able to reach him in the time that I have represented my client. This is an aberration in my attorney-client relationship with him. And despite the number of assertions in counsel's memorandum, the one thing he has never done is not appeared for court. He may have listed his house, he may have done other things, but he has never failed to appear for this court. And he appeared at the start of this evidentiary hearing, took the stand and started testifying. So I acknowledge, Your Honor, this is a bizarre set of facts, but I don't believe these facts fit in any of the cases cited by counsel. I understand he's not here, but that's the only fact that is similar in those cases. I don't believe in any of those cases a person was on the stand in the middle of testifying when the failure to appear in court happened. I don't believe any case is in the middle of evidence in that way when those decisions were issued. So I understand the court needs to make a ruling, and I've made a record base going forward, But I think the danger and prejudice to my client outweighs the prejudice to the plaintiff, even though I do acknowledge there is prejudice there. I'm not backing away from that. And I assume there'd be fees and other sanctions that would go along with that. But a continuance in order to investigate this matter and find the reason for his absence, to me, makes more sense than to proceed with this, not allowing him to put on a full defense because he's not here and he would never have the chance to finish testifying. And I'll submit it on that.
Thank you, counsel. What type of investigation do you intend to do?
I'm not sure, Judge, but the issue is it's been less than 48 hours since my last communication from the client. Granted, I mean those were comments left on the My Case portal. I can tell you that they were strategy based. Obviously, there's a privilege issue there. I'm not going to reveal, but there was no indication that I saw in anything that he would not be here.
And when you last spoke to him on Friday for that 90 minutes, did he indicate that he was not in the jurisdiction?
That topic honestly didn't come up. We were addressing specific strategy for this hearing. I had no reason to believe that he wouldn't be here, and I did know he was traveling, and I don't dispute the fact that perhaps he wasn't in the jurisdiction on January 5th. That doesn't mean that he didn't make an attempt to get back to the jurisdiction. Something else happened. I would assume he was back in the jurisdiction if he was emailing me that early in the morning yesterday. But I'm drawing inferences based upon what I have.
Going back to you, Mr. Jimmerson, and of course you can respond to counsel if you so choose. My question is, setting the contempt matters to the side, what are the most urgent matters for your client as far as needing a decision, particularly for the child? And I know we have the passport issue. I did investigate that a little bit. I guess on the order, it says only clerk of the court and not also staff attorney. If you do want to submit the exact same order, we did talk to our staff attorney who's available on the same floor and get that signed probably quicker. What other issues are most pressing for your client at this time?
Yes, Your Honor. The issue that we have is the nature of this proceeding, obviously very significant. We filed the motion back in October of 23. Getting it wrapped up, getting it finished is important because every day that this continues, obviously additional costs for my client. Also, the other important matters the court has alluded to, for example, the passport issue. Mr. failed to comply with other orders. For example, the order to retain a communication coordinator. That means that the only communications that can be done are through the counsel, through me. Because the parties aren't supposed to speak directly to one another because this man can't engage in civil communications with Ms. And as a result, he's not retaining the communication coordinator, which effectively requires her to keep her attorney on retainer. And that by itself is an inconvenience and a cost, as opposed to having someone who's not only less expensive, but is the cost being borne by the person who necessitated the need for a communication coordinator in the first place, and someone who's going to be able, who's perhaps going to be more available than I would on some days. And so the idea that you're going to have, him not be able to show up, us not wrap this up, is certainly prejudicial to my client. Not just the dollars, but because of the implications thereof. If he's missing, or if he's gone, okay, either we're in a situation, which again, we're 24 hours later, taking Mr. Treffinger's word that he made comments or communications in the case file, we're left with the statement that Mr. Treffinger attempted to reach him by telephone, and it went straight to voicemail. That's how I interpreted the emails of Mr. Treffinger.
That's correct. That's correct, yeah.
Well, if it was in the morning of Monday, either the phone was turned off or the phone ran out of batteries, right? And you wouldn't think the phone would run out of batteries, in 10, 12, 7, however long it was, hour period, okay? If something, bad happened, okay, you think you'd at least be able to leave a voicemail, okay, that it wouldn't be just straight to voicemail. You'd be able to hear the rings as opposed to going straight to voicemail. But more importantly, we're now 24 hours later. If there was some bad calamity that happened, okay, we would be knowing about it. Someone, whether it be Mr. or be a member of his family or a friend of his, would have reached out somewhere. There would have been some ability to find out what went on. And Mr. Treffinger had been supplied with phone numbers for his family members, including his mother, and presumed that he made phone calls to the family. And there had been no response, or we've got no information. And so, as a result, we're left here wondering what could have possibly happened. Either it's going to be something absolutely terrible, which this court absolutely would have the right to say, you know what, sorry, we didn't have the information at the time, but I'm going to allow for a new trial. Or we're going to be in a situation in which he is avoiding this court, which, by the way, he has done, right? He has done everything possible to avoid the justice in this case from this judge. He's tried to change the judge. He has tried to change it twice. He's then tried to change it a third time. Okay, all, by the way, before we have the hearing. He didn't seek the peremptory challenge until after we had a hearing set for the second day. He didn't seek it, in June. He didn't seek it in July. He sought it in September. And then when that was unsuccessful, he filed his application, or his affidavit or motion to recuse this court. And then when that was unsuccessful in terms of getting the court removed, it was successful in getting the evidentiary hearing date removed. What do we have now? Him failing to show up because he can't do anything else. And now seeking continuance effectively without any evidence. All the while, we have all the evidence that suggests not only is he not here, that he doesn't want to be here, that he's sought to do everything in his power to get this thing pushed off. And to allow him to benefit from this, it's not just dollars, Judge. It's getting the finality, getting the conclusion, and most importantly, Judge, incentivizing him, because ultimately, Mr. Treffinger is right, the implications here are significant. But that doesn't mean the court should delay itself. Okay, a sentence of incarceration, which again, we're talking the possibilities, not the probabilities, but certainly we believe that an appropriate sentence of incarceration would be appropriate, if not 48 years, obviously. But the idea that he would be able to put off all of this for some period of time, for him to then not show up in the future, or for him to show up and then give an inadequate excuse, to waste everyone's time, once again, not only is it prejudice to her monetarily, but also because of all of this, everything has been in limbo. It really has. Because ultimately, we've got issues now with the passport. His desire and ability to cooperate is non-existent at this point. And so if this court brings this matter to a conclusion and then issues whatever the court is going to issue, he is then going to be incentivized to show up, or at least make his excuse known. Because if he believes it is unjust that he shouldn't have had to face a situation where he wasn't present, okay, he's going to let the court know through a motion. The burden should be on him to do that at that point, because all the evidence right now suggests that he's not even here in Clark County. So when we're left with that, and his ability to come say, this is what was going on, that would give the court comfort that it should move forward here and not waste any more of this court's time. Because I can tell you right now, we can be done today if we move forward. I do not intend to have Mr. very long, but we can complete this today. And if he actually has a valid reason for not being here, it will come out sooner rather than later, rather than having us wait 60 days or 75 days or 45 days, however long the court puts us on a schedule. Because then he'll know if he's actually got a good reason. He's got to let the court know, because the court would then be asked for a new trial. Mr. Treffinger, did you try to reach out to his mother?
Our staff did, yes.
Okay. So, did we get voice? I'm sorry, I don't mean to inquire, but did we get voicemail every time?
I don't know. I believe so.
Okay. Well, specifically in your specific communications,
I had no direct communications with the family. My assistant made those.
But with Mr.
It went straight to voicemail. Correct.
Okay. This is what we're left with, Your Honor. Okay. If there was any reason that he wouldn't be here, okay, there would have been there would be something from the family saying, what's going on? Okay. If there was a situation like we're trying to reach him we can't find him, we would know about that. We don't have any of that. Okay, we've got an attempt to get in communications without any explanation for why he's absent, as compared to all of the evidence that suggests that he didn't want to be here and he's chosen not to be here. And that at least for the first time, if the court allows us to finish this thing off, the ball would be in his court to actually do something. And because right now he's doing nothing, despite the court ordering him to do things such as pay his half of tuition, to ordering him to cooperate with the application or renewal application for his daughter's passport. Right? basic things that he's just not complying with the court order, with court orders. For that reason, Judge, we would ask the court allow us to continue this evidentiary hearing. I would request the court award us attorney's fees and costs that were directly attributed to the fact that we were not continuing yesterday. We specifically request an amount of $5,675. That would include 10 hours of attorney time between the preparation as well as the preparation of the brief that was submitted today, 2 hours for Mr. Pastor's time, 1 hour for our notary's time, and the babysitting costs, because my client wouldn't have needed a babysitter had she known that we weren't moving forward.
What was that amount again, counsel?
$5,675. And we would request that amount regardless of whether or not the court continues this here, continues with the evidentiary hearing today or not.
Anything further, Mr. Treffinger?
I can't dispute the attorney's fees request at this point. I do take issue with the notary, considering there is a process in place to have that order signed. It sounds like they've engaged in that process. Even if he was here, there's no guarantee he would have signed the order. There's no I don't know why one would pay a notary when he clearly doesn't seem to be wanting to sign an order. It doesn't make sense for that expense to be put on my client. There's already a pathway in place to get that document signed. I'm not saying he's correct for not signing the order. I'm just saying there's a path in place. They've gone down that road. There's no reason to believe that if he was here, he would have signed the document anyway. Because even Your Honor directing him to do so, that's not the process. As far as the other numbers that are there, if those are the numbers, those are the numbers. Again, it's not, there's this reference being made that my client did nothing. My client spent an hour and a half on the phone on Friday and was still giving strategic recommendations for arguments yesterday morning. That seems bizarre behavior to run up his own bill when he has no intent on being here. And if it turns out that he isn't here and it's on his own accord, obviously I can't stand up as an officer of the court and make any assertion to you that there wouldn't be some sanction or appropriate conduct for that. But to say that he hasn't done anything, he's done a lot of things on this case. He's hired new counsel after he had issues with other counsel. He strategized and worked on this case. He's uploaded evidence. He's made comments on the case file. He's had the court prep phone call that I do with every client before an evidentiary hearing. The fact that he's not here is bizarre. And I think under these specific set of facts, which are indeed bizarre, the safest thing to do is if the court's inclined to sanction for attorney's fees and costs, I can understand that. I don't believe it makes sense to go forward and not allow my client to put on a full defense in the face of what he's facing in this case.
But for the request for contempt and the sheer volume of counts of alleged contempt here, this would be a very easy decision. And that's why I wanted to know what other issues needed to be handled. We have the communication coordinator issue, but we would have to generally talk about at least a temporary order to give guidance with a father who's not here regarding custody. I can't expect that she would have to communicate with him at all if he's not here and not showing up for the hearing as far as the needs for the child. But we're already in a, I'll say, use your word, counsel, bizarre situation. And I understand, thank you for your representation, counsels. As a former defense attorney, I understand the position that puts you in. You're making the record for your client. I already said yesterday I'm inclined to grant attorney's fees and costs. What I would ask Mr. Jimmerson, in consideration of the situation and that Mr. Treffinger just noted at least one objection regarding the notary, is that you still prepare a memo for that amount and include the time, the amount for the time it takes you to do the memo as well, because that shouldn't be on your client.
Yes, Your Honor. I do want to address one short thing that perhaps misinterpreted the court's question. I was speaking specifically about implications about him not being here. Obviously, I think that the issue of whether or not he should be deemed a vexatious litigant and the fees associated with that would be separate and apart from any continuance of the evidentiary hearing. So regardless of whether we continue with that, I do think that because that was set for a hearing yesterday. So I think that we would have to resolve that no matter what happens today.
Okay. your position there?
We can move forward on the collateral issues. I think that's been briefed, that doesn't require him being here for me to argue that particular issue.
Okay, so let's do that then. Let's start because we're at just 15 minutes shy of 3 o'clock right now. Let's start with the collateral issues, and I'm also fine with continuing. First of all, I am making the findings here today that Mr. sufficient notice of this hearing. I am finding that he is voluntarily not present here today and that he has waived his appearance for this evidentiary hearing so that we can continue. This is not day 1, this is day 2. Both dates were already set. What I would like to do though is handle the collateral issues. I know, Mr. Jimmerson, you said you could finish today, but it's a lot just regarding the contempt and the findings that would need to be made. So let's see how far we get. What I'm thinking is we handle everything else. I would like to address any specific issues, and I apologize if I wasn't clear, regarding Ms. and what she may need as far as a temporary order or what she's requesting regarding the child as far as contact, because essentially we have cases dealing with custody where one side doesn't show, and at least mom needs to be protected by temporary orders. Don't know, so until Mr. is able to file a motion, explain what's going on, believe the situation with the orders we have right now are pretty helpful for Ms. I don't know if there's any issues coming up. We handled school, but that was a temporary issue. I don't know if there's vacations or anything that a parent would normally need permission from the other parent or notice that would need to be handled today.
Your Honor, it's one of the facts that would have come out had we had the opportunity to ask Mr. So I would ask Ms. When she takes the stand. He has not exercised his visitation to any real degree. He has had, I believe it's 3 visits since June 23. Oh, 2 visits, excuse me, since June 23. He's not exercising his time. So in terms of getting temporary orders for things like vacations or whatnot, until he starts exercising his time, there's no need to get permission because he's not even here, let alone exercising the time he has with his child. Legal custody would be the key issue. So if there were any decisions, for example, medical decisions, I know that we've addressed school, but if there are any other decisions for which legal custody would be required, we would request a temporary order that she has sole legal custody of this child going forward.
Okay, Mr. Treffinger, regarding that limited issue.
Unfortunately, at the moment, with my client not being here and it appears that he has disabled the Talking Parents app. It's a temporary order. If he were to resurface and want a say in that, I have a mechanism for dealing with that, as it's a temporary order. Under these circumstances, I'm not going to oppose that request.
Okay. Then a temporary order shall read, and Mr. Jimmerson, you can fill in any necessary language you believe is there based on the parties' history here, and have Mr. Treffinger, of course, review and sign off, but it will be that mom have sole legal custody temporarily. She is to be able to make all decisions regarding without notice or the permission of defendant until further order of the court.
Thank you, Your Honor.
Regarding the passport, it's my understanding that the order was forwarded directly to the clerk of the court, Mr. Grierson, when we inquired about that. But if you would like to submit another order that states staff attorney, we can get that signed this week. I don't know if there's any international trips planned, but we can get that part handled.
We appreciate that, Judge. We simply followed Rule 70 in having the clerk sign it rather than the staff attorney, but we will submit with the staff attorney language as well.
As far as the communication coordinator, my ask is, did your side identify someone already and present that information?
Yes, Your Honor. It was actually a stipulation in order. We had identified Keisha Wyford, excuse me,
Okay.
to be the communication coordinator. We submitted it at the court. I had entered it as an order at the court back in June. It's just a situation in which he hasn't retained her, and ultimately, I think Ms. ultimately I'd like to have a day where she doesn't have an attorney on retainer. So that's really the implications going forward. If he's not going to be here and he's going to be absent and he's going to keep his talking parents turned off, there isn't a whole lot of opportunity for him to communicate with his daughter. So.
That's right, I couldn't remember, thank you, if someone had already been identified and we were waiting for him. Anything on that issue regarding the communication coordinator, there's really nothing I can do, he's not here.
And it was before my time anyway, I wasn't involved in those conversations.
Application is turned off, no one can reach him. And he's only exercised visitation twice since June 2023.
June 23, 2024.
June 23, 2023.
So the Sunday after our evidentiary hearing, and then he had her for her birthday, which was that day on June 23, and then and then November 1st and November 3rd, are the 3 times since our evidentiary hearing on June 21 that he has exercised time with the child.
Okay. So let's start then with the collateral issues that were not decided and passed from Chief Judge Weiss' calendar that have already been briefed.
Yes, Your Honor, the primary issue is the identification and finding that he is a vexatious litigant. The court's read the briefs on this. Mr. When his relationship with Mr. Page, his prior counsel, went south, he went on a filing binge. He filed 29 different documents across approximately 35 days, nearly 1 filing per day. Those documents were in large part frivolous. We had we had orders of this court trying to maintain hearing dates after he filed improperly multiple peremptory challenges. In responding to the identification of his improper peremptory challenges, because amongst other reasons, he filed it in an untimely fashion. And as you know, Supreme Court interprets Supreme Court Rule 48.1 rigorously, because the effect of changing the judge not only presents a burden on the court system itself, but also to the extent that there are imminent proceedings, the parties as well. And so when he files these peremptory challenges in an untimely fashion, that's one thing. But then when it's brought to his attention that it's untimely, he then doubles down and says, no, it was timely, because theoretically, filing within 23 days is the same thing as filing within 10. That's just one example of the frivolous positions he has taken. The court will also notice that despite the fact that he had been, if not informed of, reminded of EDCR 7.40's requirement that parties who have retained and appeared through counsel only have counsel file documents on their behalf and appear through counsel, he rejected the application of that rule and continued to file over and over and over and over again, despite Mr. Page being his prior counsel. Moreover, Your Honor, the court has seen what this man has done in its direct communications, or its staff's direct communications with Mr. In his patently frivolous affidavit in motion to seek recusal of this court, Mr. had communications with this court's staff concerning the staff's email saying you need to come pick up your binders. The staff attorney has advised us that the best juncture is that these are unfiled documents that need to be picked up. I'll read specifically the email. Mr. Per the staff attorney, the binders would need to be returned. Arrangement of a pickup appears best at this juncture, as these are unfiled documents not suitable for anyone's review here at the court. Please let me know when you will be coming to pick up all documents that were delivered. Thank you. Very respectful, civil, appropriate email by this court staff. In a 24-minute period, Mr. 5 emails in response, making patently inappropriate statements towards this court, including but not limited to the following. We're already getting the Supreme Court Appellate Division involved as per your department's illegal actions in violation of NRS 1235 yesterday. If there are other supervising bodies you would like to involve in this matter while subverting due process and placing the blame on the applicant, please specify. That's one email. Another email. Your statements are untimely, misleading, and highly inappropriate concerning the proper procedures for the district court, and therefore unwelcome. But thank you for this demonstration. Another email. Again, this is all in response, just that first email. Please pick up the unfiled documents. I'll not tolerate misrepresentation in this matter by a department that treats submissions and motions by this party as though they vanish upon receipt for over 6 months. There's no basis for Mr. saying any of these things. But this is what he does with courts when he doesn't have counsel. When he chooses to file these things and communicate with the court in this way, everyone suffers. The court suffers, everyone suffers. So we get a litany of filings that have no business coming before the court. It results in a continuance of an evidentiary hearing. It wastes the court's time. It requires my client to file documents to protect not only those days, but also to respond, because ultimately the prejudice to my client is, once again, we would have a reassignment from this court to another court who is unfamiliar with the matters and effectively restarting the issue from square one. Mr. right now has counsel. I don't know how much longer he's going to have counsel. What I can tell you is this: a finding that he is a vexatious litigant protects the court and protects Mr. from further frivolous filings. Because while he has counsel, and the requirement is that Mr. Treffinger or whoever his counsel is file documents in his behalf, we have the adequate protections. But if Mr. no longer to go through his attorney, or if he chooses to end his representation, as the court has seen, he is in once again an overlength and improper brief called a Feretta declaration, where he asserted his right to appear on his own behalf. That is the reason why you would need to find him to be a vexatious litigant, to prevent further improper filings by him. And in so doing, the court should find and order that were he to seek to file documents outside of counsel, that he receive leave of court to do so. That would provide the court and the parties the appropriate protection, and that would also limit any sort of prejudice to Mr. If he's represented by counsel and filing documents through counsel. This would have no effect on this matter whatsoever. We would also request, Your Honor, we supply not a memorandum of fees and costs, but a simple declaration, an award of $8,550 associated with the filing of those papers in the preparation for this matter as a result of Mr. improper and frivolous filings that need to file a request that he be deemed a vexatious litigant. Thank you, Judge.
Thank you. Okay, Mr. Treffinger?
And clearly, I'm not going to stand here and say that all of his filings with the court are proper, done within the rules or anything like that, because I am a realist at the end of the day, and I don't stray that far into making baseless arguments. I will say this, regarding the recusal, Judge Weiss heard that motion on the merits. He did not strike it. He did not refuse to hear it, which is well within the Chief Judge's power. If he felt that it was done improperly, that was not done. Despite counsel filing for an order shortening time, which was not granted, Judge Weiss did not feel that that argument bore upon whether or not he should actually go through the elements of a recusal case, which my client does have, or any party in any litigation has a right to file for a recusal, and it was denied. Again, denial and frivolous are not the same thing. There was no finding made by Chief Judge Weiss that the motion was improperly filed, that it was vexatious in any way, or that it was frivolous. He simply walked through the factors and denied it. He took it through the process. He didn't hear argument on it. Granted, we had arguments set, and it was taken off a day or two before, but that was taken in that way. The email sent to the court, do I agree that some of that language is inappropriate? I mean, he's asserting what he believes in that moment. I can't tell you why he sent 5 emails in an hour period, or 20-minute period, I should say. I wasn't counsel of record at that time. I know there was issues with Fred Page, and I believe what is being demonstrated here is my client feeling that he had no voice in the matter and was unable to get Mr. Page off his case or communicate effectively or whatever was going on there, was trying to have his voice heard. And I'm not saying that the way he went about it is appropriate. I just don't know that it rises to the standard of being a vexatious litigant. The emails to the court has ways to protect itself. The court does not need protection from the vexatious litigant statute. It is other litigants generally that are being protected by that. The court has plenty of remedies to stop inappropriate conduct, deny motions, give sanctions, and do a variety of other things. I think that this is being escalated to a level that it doesn't need to get to, and I think when you have to couch these things, when you already have thousands of pages of documents being filed and you have to refer to 5 emails sent to a clerk, I'm not sure that is what the vexatious litigant standard is for. He does have counsel now. I don't intend to come off the case if he were to decide to fire me. I suppose that's something that could happen down the road. But I intend on seeing this case through to the end. But I don't have a crystal ball, and neither does Mr. Jimmerson, frankly. We have the situation before us, and I'm not sure that what's on file in this case raises to the level of deeming him a vexatious litigant. I'll submit it.
Anything further, counsel?
Yes, Your Honor, I just want to remind the court that while any litigant would have the opportunity, the right to file an affidavit or motion to seek recusal, that is not a license to file something that is frivolous. That's not a license to make patently untrue statements. And for example, beyond the emails, he states to this court, Exhibit 6 is Judge Deidre Butler's submission of plaintiff's stayed motion to district court for the disqualification motion instead of defendant's affidavit/motion, suggesting to Judge Weiss that you had preferred our motion to strike over his own motion to disqualify, which we know is patently false because it was routed directly to Judge Weiss because that is who handles matters of recusal. He tells this court, despite Mr. Page no longer acting as defendant's attorney, the court has improperly forced him upon the defendant as counsel of record. That is patently false. That is demonstrably false. No one forced any attorney on Mr. He hired Mr. Page, and then Mr. Page decided to withdraw with the permission of the court. He states to this court the defendant cannot even access district court filings. He must submit motions, including the opposition by mail. Also demonstrably false, as evidenced by the electronic e-filing stamp at the top right-hand corner of the page of that document that was, oh yes, e-filed and electronically served. He attempted to seek recusal of this court on the basis of, quote, the refusal to grant a hearing on essential procedural violations, such as the motion for disqualification, constitutes a clear violation of defendant's due process rights. He made that statement in his objection to our motion to strike, which was filed, by the way, Judge, after Judge Weiss had already set a hearing on the matter. Mr. over and over and over again demonstrated that he is untethered to the facts, to the truth. And so when left to his own devices, we get filings that contain and reflect demonstrably untrue sets of events. And as a result, Your Honor, the court should find that he's a vexatious litigant. And because we have the protection of Mr. Treffinger here, okay, ultimately the prejudice to Mr. is none. The protection that would be afforded to Ms. however, is substantial in light of what we know Mr. already done. He has already demonstrated that he is not going to follow the rules when he chooses otherwise. He's going to do what he wants to do. So an order of the court that allows Ms. protection, affords her the protection of not having to respond to everything unless the court says you have leave of court to do so, gives her that additional protection and allows her to move on. Hopefully at one point she'll no longer need an attorney because we'll be done with these proceedings. Otherwise, Mr. demonstrated that he, will enjoy being a keyboard warrior and filing whatever he wants to file if the time suits him. Giving her this protection is appropriate, and especially because he has Mr. Treffinger right now, the prejudice to Mr. is non-existent. For that reason, Your Honor, we would request not only that the court find him a vexatious litigant, order that he must file documents through his counsel only, or if he appears on his own in proper person, that he seek leave of court before filing anything with the court and award the appropriate amount of attorney's fees and costs. Thank you.
Anything else, Mr. Treffinger?
No, Your Honor.
Okay. So regarding the identification of a vexatious litigant, I am finding that we're a little premature there. I do understand that there was, I'll say, discontent apparently with the last council, and I believe you said filing binge council, that Mr. to file several pleadings and documents. I'll say this, the court is pretty protected. Before today, I had no idea that there were, for instance, multiple emails with court staff. So of course, my law clerk and judicial executive assistant do not involve me in any communications with the public. So I was unaware of that. And with the filings, I want to focus primarily on any prejudice to Ms. because it is problematic when a motion is filed and plaintiff feels the need, of course, to file a response, file an opposition. And if the motion is frivolous, or I'll say confusing, doesn't really make sense, and it's hard for a plaintiff to even ascertain what's being requested, of course, that can lead to a waste of time, a waste of money, et cetera, et cetera. So what I will do, I will not deem Mr. vexatious litigant at this point. I do have to balance access to justice, and that is an extreme remedy. Typically on our list of vexatious litigants, we have litigants who have been for years filing multiple documents, hundreds and hundreds, maybe thousands of pages, and are typically self-represented. At this time, with Mr. Treffinger as counsel, I will make the following orders. 1, any pleadings in the case from defendant must go through counsel. That's what we're dealing with right now. I cannot assume or speculate that you at some point will not be on this case, counsel, as you said. If self-represented, this is what I'll say, if that changes, and if self-represented, I will order that Mr. must seek leave of the court before filing a motion as a pro se litigant. That way there's additional protection there. And what will likely happen is if Mr. self-represented and starts filing pleadings, then there's communication there, right? We understand that he's trying to avail himself of relief from the court. He's not, I guess he's no longer missing at that point. And so we would schedule a hearing to address his absence at these evidentiary hearings. Certainly handle what's before us now before addressing any requests by Mr. here to handle these matters. So it's a long road before addressing any requests that would potentially be filed by Mr. pro se litigant. We can also readdress the request as far as identification of Mr. vexatious litigant, if and when he's self-represented, and if and when the occasion comes where he starts filing numerous motions. At this time, while I am finding that there were a litany of motions filed, many requests, which I'll just say at this point are confusing, I was hoping Mr. be here to explain some of his requests. And actually in this case, I will say I was pretty surprised at the number of filings, because Mr. self-represented before bringing Mr. Page onto the case, and we had open dialogue and conversations. I thought he was representing himself very well, frankly, and he was not engaging in activity that typically leads to a pro se litigant being deemed vexatious. So there does seem to be a break and some bizarre behavior after that last hearing when he was present. And maybe a lot of that has to do with his representation by Mr. Page. I don't know, and it's not appropriate to speculate any further. But, and of course, item 3, I am finding that attorney's fees and costs are appropriate here as requested for having to respond, particularly in light of the situation now where Mr. not here to present any information to support his request or to explain his request. So Ms. kind of had to figure out what he was asking for and formulate a response as best as she could through counsel, and of course had to pay for that. So your request to submit a declaration is granted, counsel, and I'm inclined to grant the amount requested, which was $8,550. But again, upon review of your declaration once submitted, of course, Ms. Treffinger has the right to review that, as well as the memorandum of fees and costs for yesterday, and file an objection if counsel deems it necessary, even if that's an objection to partial request for fees and costs.
Yes, Your Honor. We'd submitted a declaration yesterday supporting the 8550. There weren't a whole lot of line items in that regard, so in terms of presenting invoices or whatnot, that was there. But if Mr. Treffinger has an objection to that, I'm sure we'll see it.
Okay, and I do see that this was filed yesterday morning. It's only about 4 pages, so of course, Mr. Treffinger, I will wait and give you appropriate time period for an objection, so you have time to review that. It is really short though, and then once we receive the motion, the memorandum for fees and costs for yesterday, I'll hold that as well, so council has time to review and decide if you want to object there.
Yes, Your Honor. And what I would do is I will put in, and we'll submit the order, I'll put in a blank line for fees and costs, so the court, after, is it 7 days for an objection to our declaration? Is that?
I give 14.
14, okay, 14 days.
7's fine, Judge.
Okay.
Okay, 7 days,
better,
just
7.
so that I'll then submit an order. Obviously, I'm gonna run it by Mr. Treffinger first, but it'll have that blank line, it'll have your ability to add to it as appropriate.
Any fees and costs ordered shall be reduced to judgment and collectible by any means. Make sure that language is there.
Yes, Your Honor.
Okay, Mr. Jimmerson, what's the next issue if we have any other collateral issues?
No collateral issues, Your Honor. We would like to proceed with the continuance of the evidentiary hearing,
Okay,
or continuation, excuse me, continuance versus continuation.
okay, so we can continue councils for today's purposes, and again, I apologize for the courts, the delay yesterday and today. I do like to give time to see if all parties will appear, and today we just had an incredibly long calendar. I think we stopped right at 1:30. We do have our clerk filling in, so today we'll go to about 4:30. Mr. not here, so we'll have Ms. take the stand then, unless you had any other witnesses that you were going to call.
No, Your Honor. We're happy to continue with the evidentiary hearing with testimony.
Okay, Ms. if you please take the stand, and Madam Clerk will swear you in.
And just for the record purposes,
Yes.
and just so I'm not making this objection continuously, I have a standing objection to continuing with this today, so I would be objecting to every witness and anything else presented today.
Noted, counsel, thank you for making your record.
Remain standing, raise your right hand. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, may be seated.
You may be seated. If you please state your full name and spell your last name for our record. Thank you.
Good afternoon.
Good afternoon.
Can you tell us a little bit about yourself? Introduce yourself to the court.
Yes, hello. I am a single mom. I'm a musician. My daughter is the love of my life. She's amazing, and I'm so grateful for her. The last couple years have been very, very, very challenging. I was a caregiver for my mom who passed away from stage 4 cancer, and at the same time a single mom to a 16-month-old daughter, and we all lived together, the three of us. That's when the abuse that I feel like the height of it was from the day my mom got diagnosed till the day I held her and she took her last breath in my home with my daughter present. And I just feel like this has been a really, like, I forgot who I was before, and I want to move forward. And I have amazing, amazing daughter, and we have a great relationship, and I really, really, really want to know what it's like without all of this looming over me and in my energy and in hers.
Let's talk about your daughter.
Oh, yes.
What is your daughter's name?
Her name is
And when was she born?
2019 at 2:17 a.m.
And where does she go to school?
Currently at
And what grade is she?
kindergarten.
We had heard significant testimony from Mr. during some of the events and questions, the statements at issue. And I'm going to focus specifically on a few events that we didn't get into with him in an effort to avoid any duplication of testimony or evidence. So we had addressed prior, in the prior evidentiary hearing date, communications he had had with your father. What we didn't discuss were some of the communications that he had with you about your mother. Do you remember those communications? Can you testify?
Yes, I do remember that.
There came a time in September of 2022, where the court provided additional protection concerning communications about you, your family, and your loved ones. Do you remember that?
I do.
Okay. And do you know what precipitated that stipulation and order to expand the protection in terms of communications, Mr.
Yes.
What were the events, what were the statements that caused the agreement for him to refrain from communicating in an abusive or uncivil fashion about you, your family members, your friends?
I don't understand your question.
What statements did he make about any particular family member, including but not limited to your mom,
Okay.
that would have been the reason why you sought the additional protection from the court?
You want me to say what I
Yeah.
remember, what they were?
Correct. Or just generally?
Yeah, no, I mean, honestly, there's the one that sticks with me, like, just that I have absolutely forgiven him for, because not doing so would just be harming myself, and I don't have space for that, being a single mom, but that I have not forgotten, because I just don't know how someone could even think of this, but I wish that old CUNT or something to that extent could die twice. Like, I've never heard someone wish that someone could die twice, especially someone that is the reason that your granddaughter has a home, has food, has education. It's not because he pays child support on time or at all without a lawyer reminding him. It's not because he has ever spent a night with her in his life. It's not because he's ever driven her to or from school. Like, everything she have is not for my yoga salary of $1,400 a month. It's because of my mom. And to, like, wish death twice on a woman who just died a really, 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 just a really, really long, slow death into, like, I felt his visceral hate for my mom and me through his talking parents messages and video calls and voice, and I just heard it over and over and over again, to the point where I'm so grateful. I will say, like, this is, I believe God, like, 45 days before my mom died, I was granted a TPO. So for at least the last Like, it was just so crazy. Like, my mom died on March 20th and the TPO was over March 26th. So for the last 6 weeks, I had peace and I was able to be present with my mom, which is all I wanted for those 13 months. And I couldn't because I had someone constantly making it more difficult to be a parent and to be a caregiver with someone who had cancer in several organs in her body. Oh, and then another one that comes to mind, just because I thought it was like, again, who thinks like this? Let me know where that old bitch's grave is so I can fertilize it regularly. Like, I don't even know what that means, but I know it's really disgusting.
Mr. Pastor, can you please bring up this bit of admitted evidence, Your Honor? Exhibit 57. 57, 57. It's the Talking Parents message record.
Yep, what page?
PDF page 556, and it's Bates label 17607.
Sorry, it's 556.
PDF page 556. And can you please scroll to the bottom of this message? This is from, as we actually, can we scroll up to the top so we can just see the date and time right here? Ms. Tell us the date and time of this message. As
January 30th, 2023, 3:55 p.m.
Okay, and Mr. Pastor, can we? Yep, scroll to just in the middle of that page, so right above the to try napping at school. Can you please read the last 2 lines of this message that we
Oh,
see?
yes, I will. I remember this one. But I will always have reverence and celebration on the spring equinox. My 2 regrets are that she died so slowly and that she can't die twice.
Is that the message that you were referring to earlier?
Yes, my mom died on the spring equinox at 3:20 a.m. in
No.
my hands.
That was March 20.
Yeah.
If you take a moment.
Thank you.
Do you have any significant health conditions?
I do.
Take your time.
I'm good. I'm good.
What are those health conditions?
I have ulcerative colitis. I was diagnosed in 2017. It's like your GI tract. It's a autoimmune disorder, essentially, where you have inflammation of the colon. My mom also died of colorectal cancer. And from a spiritual standpoint, the colon is literally where you let go. Like, your colon is where you release. And I just feel like I can't say he gave me colitis because he's not that powerful. But my doctor has told me that stress creates flare-ups.
I'm
And
going to object to hearsay at this point, Judge.
Okay, sustained regarding what your doctor told you.
okay,
You can continue.
that beyond medication and sometimes 3 colonoscopies a year because of findings, that the way I can reduce my flare-ups is reduce my stress.
Is colitis a terminal illness?
No. No.
Can it be terminal?
Yes.
Has Mr. comments about
Oh,
your,
yes.
your colitis and the
Many.
effect
Many.
they've had? Can you give us an example?
Can I paraphrase because I don't remember exactly?
I'm going to show you an example later, so
Okay, so yeah, I mean, the one that I'm thinking of now is, it doesn't really matter if I don't see, because statistically, I'll have her for the rest of her life when colitis kills you, or something to that effect. Or she'll be with me the majority of her life. What colitis is a good thing, or something like that. Something to that effect. I don't even remember.
Mr. Pastor, can you please bring up page 451? It's going to be Bates label 17502 from the same exhibit, Your Honor. It's been admitted in evidence. I refer you to the July 19, 2023 statements.
Oh, yeah.
Do you see the highlighted text?
It's really blurry.
Do you see that message right in the middle there?
Yes. Oh, that's perfect. Yeah. But just scroll a little bit to the side so I could. Yes.
And what is the date of this message that was sent to you?
July 19th, 2023, 12:09 a.m.
And can you read beginning the second paragraph? Oh, actually, begin at the beginning.
Heading to the courthouse tomorrow, you miserable hag. Colitis is a wonderful thing. You can keep yourself all you want for now. I'll have her for the majority of her life. She'll see the daily videos and emails I made and set aside for her. And I hope it accelerates. Honestly, the sooner the better.
Are you worried about whether or not the colitis could affect you to the point of?
Absolutely. My mom died from colon cancer and it's genetic, and I am vigilant with my colonoscopies, and I'm vigilant with my alternative holistic remedies, and I'm vigilant with my GI appointments every 3 months and my blood work. Like, I am doing everything I possibly can to keep myself healthy so that I can be here for.
Just have one request, and I
Yes.
appreciate you testify passionately as you always
Yes.
have, but please allow your counsel to finish the question for the record,
Okay.
because I know you probably know where he's going with it, but I don't always, and I don't want to assume, so just want to
Okay.
make the record really clear.
Yes, I understand.
How did it make you feel reading these words?
If I'm being honest, in this moment, I've had to disassociate his words and his, because it's just words. Like, it's words, and in the moment, I know how it made me feel. I imagined what would happen gone, and that feeling is horrible. But reading it right now, there's just so much that is on my plate, bandwidth wise, that I have to do, that, like, I'm just being honest, like, I don't even realize, like, this is, I don't know how to really answer that. I know I sound weird right now, but like, my brain has had to like compartmentalize to function. I don't know how I feel reading that right now. I just kind of want to move on from this.
Mr. Pastor, can you please bring up exhibit 114? It's going to be page 1 of that exhibit. It's going to be Bates labeled defendants 16.205, 1593. It's the bottom of it. This has also been admitted into evidence. At the beginning, or excuse me, the middle of this page, Mr. Pastor, keep scrolling up, please. Right there in that middle section there. Ms. Can you please read that short message in the middle of that screen for you? Screen, please.
Yes. Also, let me know where your hateful mom's grave is so that I can fertilize it regularly for the flowers.
Is this the message you were referring to?
Yes.
About fertilizing?
Yes. He said that before she died. I think right after she was diagnosed. Because it's text message, not talking to parents. But it shows you why I needed talking to parents.
In addition to the written communications that we have seen, were there any either video or audio recordings that you have that illustrate some of the communications, or excuse me, some of the abusive communications for which we are here today?
Yes, I was only laughing because I have a Nest video, and what came to mind is when he looked directly in my Nest camera, and it's almost like he gets off, or he like starts to get bolder with his abuse when he's on camera. Like, I don't understand it. But yeah, I do. I remember. I don't know if it was Nest or Nanit, because she was so young at the time, so I don't know if it was in her, like, what kind of device, but there's video of him doing it in front of me.
Mr. Pastor, can you please bring up Exhibit 49? And this is not the any evidence, Your Honor, so I'm going to lay the foundation first.
Okay.
What date was that event that you just described, that Nest video that you were just describing?
It was in February of 2022, because it was what made me go to family court and apply for a TPO and have it granted.
And would it, no,
Early February of 2022.
So would February 4 be on or about the date of that event?
Yes,
Okay, February 4, 2022.
I believe so, yes.
How was this Nest video recorded?
I have Nest video cameras in my home. I have two, one in the kitchen and one outside my home. And it was the one in the living room.
So you said one outside the home, one inside the kitchen, was that?
Well, it was where I was living, like the kitchen and living room is connected. So it's technically on like underneath the TV in the living room, but it faces the kitchen and living room.
And have you supplied the videos from February 4, 2022 to the court as part of this proceeding?
Yes,
Okay. And do the videos that have been supplied to the court fairly and accurately represent what is depicted on them?
yes.
Your Honor, I'd like to move Exhibit 49 into evidence.
Okay, any objection, counsel?
No objection, aside from the standing objection.
Mr.
Exhibit
Pastor,
49 is admitted.
what I'm going to do, Your Honor, because we had a little bit of an issue with the sound last time, so I'm going to play the sound here, and we'll watch the video up there.
Okay.
So I'm going to hopefully good here, and then I'm going to play it. Mr. Pastor, in 3 seconds. 1, 2, 3. Here we go.
I've never called you a name and.
You've never called me a name. You've never tried to separate me. You stop being a father. You think that doesn't have an effect on people, you fucking kite. You never extorted me for money when you're really a fucking son. You extorted me for money. Yeah, I hate Judge. I called her a fucking kite because she tried to extort me. You're goddamn right. I would call someone a kite for doing that. Take away my fucking rights, please. I will pay you $100,000 to take away my fucking rights. Take away my fucking rights. I don't have rights anyways. It was a farce. It was just a fucking bullshit agreement so this kite can extort me. I never had rights. I will never have rights. While that kite is alive, I will never have rights. It's okay to your mental health because you want to start shit. Here you go, kite. You drove me crazy enough to finally go crazy. You like this, don't you, guys? Now why did you start again and again? Bring up groceries so I can verbally abuse you. Bring up groceries so I can verbally abuse you. You fucking kite. Now you go patient her.
What was that exhibit number, counsel?
That was Exhibit 49, Judge.
Thank you.
Did we see them in the video?
Yes.
And would I be correct in confirming that what he was calling you was the Jewish slur?
Mhm.
K-I-K-E, is that right?
Yes. May I say something about that?
What would you like to say?
What I gathered from watching that was the fact that my mom's dog was at my house, which meant I could tell you exactly what was going on in my life besides what you just saw there. 6 weeks before my mom died, she was in the ICU for 28 days, and the reason he was in my house with his shirt off is because I begged him, because you couldn't bring anybody under the age of 16 into the ICU, and I don't have anyone to watch her because I had never left her with anyone except my mom. I said, will you please watch Azzy so I could be with my mom? The doctor said there's a 50-50 chance she'll die in surgery. So I thought he was doing me a favor by being there for me. And I was so desperate, and I'm embarrassed that I was so desperate that I let him in my home. But looking back, I wouldn't have changed anything because I wanted to be with my mom. And I just, like, what was going on in my life, like, now I look at that, I'm like, I would never let anybody, I wouldn't be bargaining with him to stop. It's affecting her mental health. I would have just got her in my car and I would have left. I wouldn't have sat there and exposed her to it. And I'm just, that's what came to me watching it right now.
Mr. Pastor, can you please bring up Exhibit 6?
Is you okay to proceed, or do you need a break?
No, I'm okay. I just haven't watched these in a long time.
Just know if you need a break.
Oh, thank you.
Your Honor, we would move to the admission of Exhibit 6 as well.
What is Exhibit 6?
It's another video from the same day, February 4th.
Any objection, counsel?
Same foundation.
Well, yeah, correct, same foundation.
No objection, aside from the standing objection.
And I'll confirm, is this, from based upon the first screenshot we see here, is this another one of the videos that was recorded by your Nest camera on February 4th,
Yes.
2022?
Okay, Exhibit 6, admitted.
I'm gonna start right now.
You realize how damaging this is to her health? You don't care about her at all. You wouldn't be doing this to her in this way.
You
Think about
made your choice. Okay, why don't you call the police and find
Stop talking and
Why don't you call the police and find her? You want to call the police and find her? Go ahead, call the police and find her.
For 5 more minutes, talk to
Call the
her.
police and find her.
I'm not doing anything. Spend time with your daughter.
You're talking over me, I wasn't speaking to you first, you spoke to me
You're
first.
in my home.
You said the words to me first. When you speak to me, I'll speak to you right back, Ty. When you say anything to me, Ty, I'll say something right fucking back.
Please talk to her.
I was talking to her, so you fucking interrupted me.
Please
You
talk to
interrupted
her
me.
doctor.
I'll stop for you, Sean, you your mother's a fucking kike. I hope you never become like her, your grandmother.
Okay.
Apply yourself.
Leave my house now, and I'm telling you this to your face. This is
Oh.
abuse and this is not.
Oh, I'm like the extortionist, the extortionist kike. I'm like the extortionist kike.
This is.
You're goddamn right, I never come
I would never ever.
You're goddamn right, yeah, you just extort me instead, you fucking kike. You just emotionally blackmail me instead, you fucking kike. You try to stop me from getting groceries, right? You just threatened my mother, right? You kike, right? You fucking kike, that's what you would do instead.
Take me right now.
I'm not interested in doing anything you tell me to do.
I will call the police if you're not.
Please do, I'll call them first. I'm saying you will, am I leaving or not? Can I leave or not?
You're leaving.
Yeah, I'm yelling because I want you to stop fucking talking to me. Stop fucking
I'm
speaking to
saying,
me.
please leave now.
Exactly, I'm putting my socks on and I'm leaving. I'm packed, I'm ready to go.
You realize you couldn't even last a week. You're never gonna get.
You never, and you're right, I never could or would be a father. With you as the mother, never. And I never will be. It doesn't even matter my last name.
Was that video from later in that morning, February 4, 2022, after the video that we saw of Exhibit 49? Also confirming that you heard the same Jewish slur that I heard in this Exhibit 6, is that right?
Yes.
Did there ever come a time where Mr. threatened to harm you?
Yes.
Please describe that time, ma'am.
Which one?
Did there ever come a time where he threatened to kill you?
Yes, multiple.
Did he ever threaten to kill you and dance in your blood?
Yes.
Objection, leading.
Overall.
Please describe that event, ma'am.
I remember that I was in Utah and sitting on my couch. I was holding. She was very little. Couldn't have been more than like. She was before she was 1, like between 8 months and 1, because she was still breastfeeding. And I remember he got in my face and bit my nose while I was feeding her. I was sitting on the couch and he like stood over me and bit my nose, and I said, "You need to leave." And I remember he left. And then as I was gonna call the police, he called me. Maybe I called him. Let me say this correctly because it was a long time ago. I believe I called him because, again, I was a single mom, had a newborn. It was during the pandemic. I just moved out of my apartment, and that's why I was in Utah, because I remember I went May 1st is when my lease started, and it was right after the March of 2020 pandemic. And I just remember that he came to help me move essentially from Las Vegas to Utah. And after that event, I remember there was a phone call, and that's when he threatened to kill me and dance in my blood, or he'll dance when I die. I don't remember the exact words.
Do you have a recording of this
I do.
communication? Why did you begin recording this communication?
Because he had just bitten my nose while I was breastfeeding our child, and I was terrified.
Have you supplied a copy of this communication to the court as part of today's proceeding?
Yes, and as part of other like temporary protective orders that I was granted.
Does the recording that you took, does it accurately and fairly reflect the communications that are recorded on it?
Absolutely.
Your Honor, I'd like to move into evidence exhibit 48.
Counsel?
I'm unclear, when is the date of this alleged recording?
It was it was
I-
the pandemic,
May
2020.
May 15th, 2020. It said on my voice.
I've got the list of exhibits here, Your Honor. Apologize for 1 second.
May 15th, 2020.
Okay.
My only objection would be based on the timing, I'm not sure the relevance, it wouldn't be relevant to contempt proceedings for a behavior order that's issued long after 2020.
Behavior order was issued on February of 2020.
Oh, my mistake. I mean, improper note on my part, I had this 2021, I believe.
No.
I withdraw the objection.
We can proceed then?
Is 48 in evidence, Your Honor?
Yes, I'll admit 48.
I don't want to give you anything.
I'm coming right now.
I don't want you to come here. You
I'm coming
can't.
to fucking kill you. You understand? I'll stab you to fucking death.
I just want you to FaceTime your daughter. That's all. I don't want to talk to you.
Shut up, bitch. You're a nasty kangaroo kite. When the fucking disease that you have fucking kills you, I'm gonna dance.
Oh,
Turn
no.
my phone off until I get a mute.
You said that you had sought orders of the court to protect you as a result of these interactions with Mr. Hear that correctly?
Eventually, yes.
Okay. Were you afforded that protection?
Yes. One time I wasn't. I've applied twice.
Why didn't you seek a order of contempt at that time?
I was taking care of someone who was terminal and taking care of a young child. And I had the protection of my protective order. And I was concerned about immediate protection. And around that time, I was just trying to get through hour to hour.
Did Mr. suffer any criminal punishment for any of these events?
So one time, I've always called the cops when these things have happened, and they came and they gave me a card. One time he was arrested. But in terms of, I was told, I remember very vividly, it was downstairs in this room, not this specific room, but this floor, and there was a judge, and he said, while this is harassment, and this is stalking, and this is horrible behavior.
Object to hearsay.
Your Honor, I would offer it just the effect it had on the listener, not necessarily for the truth of the matter, sir.
Okay.
That you need to.
I'll allow it, but I'll note that not for the truth of the matter asserted. I don't have a case number or anything before me to even look at minutes, but only for the effect it had on you. But go ahead, you can answer, ma'am.
Okay. That he said, while this court deals with domestic violence, this is more stalking and harassment, you would need to go file a police report, which I drove from here to the police station and filed a police report. And that was in July of 2023. And I followed up with the detective. Every time he kept harassing me or called me 50 times in 1 hour, I would email all the things, and that's eventually when I reached out to you and hired you. And when this all, I think the motion was October 2023, so it was shortly after that. So the reason I didn't before is because of the reason I just gave you, and that's the truth. I just had a lot going on in my life.
In terms of the report to the police where you were referencing appearance here in this courthouse in 2023, was that related to any of the recordings that we just listened to or saw? Or was that a different event?
It was, I remember not just the recording, but there was a July 17th, 2023 thing you had me read a very short time ago. When you said read the date, I think it was one of the comments about my mom or colitis killing you. It was that around, I want to say that week that happened.
Okay, I was specifically making reference to the 2022 videos that we saw or the audio tape that we just listened to from May of 2020. Those recordings weren't related to what you saw in 2023, is that right?
That is correct,
Okay.
yes.
And I was gathered then that the other request for a TPO was related specifically to the February 2022 incident that we just reviewed, is that right?
Yes, and that was granted.
Okay, but the May of 2020, you did not seek protection from this family court.
6 months after that.
Okay.
But I would have.
You had stated earlier to the court, or we made representations to the court, you'd stated in your declaration at one, now that you're on the witness stand, I want you to testify about the time that Mr. exercised in the last 6 or so months. How many times has Mr. exercised visitation with June 23, 2024?
Including June 23rd?
That's fine.
Including June 23rd 3 times.
Other than those events, the June 23 and then the 2 other times that he saw, were you aware of any efforts that he made to secure the supervisor for any such visitation?
He made representation, talking parents video that he did. So then I reached out to the supervisor and she said, I have not heard. And there were other times that she did reach out to me and sent me text messages that are saying that he's not going to, again, it was similar to stuff you were reading earlier, just like, it was very confusing, just like he used a lot of big words, talked about how this is jurisdiction, legal, like I didn't understand it, but she screenshotted a message from him of the reason why he wasn't going to try to see his daughter, because I made a point of always reaching out to her approximately once every 2 weeks. I mean, in the beginning it was like once a week, but then it kind of went less and less because I realized like I'm reaching out to this woman who's not our communication coordinator, just trying to like see if he reached out, and she always responds with the same thing. I haven't heard from him. I promise I'll let you know when I do.
Objection, hearsay.
Sustained.
There's text messages
Hold
and
on.
talking parents.
I'll ask another question. Have you ever been requested by the supervisor to have ready for a visit with Mr. outside of the 3 times that you identified since June 23, 2024?
No.
Has Mr. obtained the communication coordinator as ordered by the court from July 15, 2024?
Not to my knowledge.
Did Mr. cooperate with you to secure the passport renewal application to be submitted?
No, he did not.
Was there an order that he do so?
Yes.
Was there an order that Mr. pay for 1/2 of this tuition for? Did Judge Butler issue an order for Mr. pay for 1/2 of the expenses, the tuition for?
Yes.
Has Mr. satisfied or complied with that order?
No.
Nothing further for this witness at this time, Your Honor.
Okay, thank you. Cross-examination, Mr. Treffinger?
No questions, Judge.
No questions. Okay. Noting that, counsel, did you have anything further?
No, Your Honor. You rest.
All right, Ms. You can leave the stand, thank you.
Thank you.
Mr. Jimmerson, from your side, any other witnesses?
No, Judge. We rest. I didn't know if the court heard that, sorry about that.
Okay.
We rest.
Done. All right, moving over to you, Mr. Treffinger.
Unfortunately, due to the absence of my client, I had no witness to call, and therefore I rest.
Thank you. Counsels, are you prepared to, I don't think we talked about this with everything going on, give closings orally? Of course, even on these issues, it's always the preference to receive proposed findings and conclusions of law. Would you prefer, I don't know if you talked about doing that in writing or proceeding orally here today?
Your Honor, I'm happy to offer a closing statement, or closing argument. I would alert the court that while we had submitted a proposed findings of conclusion of law and decision for the court, that was prior to yesterday. And so I would request the opportunity to supply an amended proposed findings of conclusion of law and decision for the court's review. And if the court could give us 7 days, 14 days in order to get it to the court, that would be much appreciated. If the court would also like to hear oral argument in conclusion for today, I would like to do that as well if possible.
Your position, counsel?
I would prefer to do it in writing, just because I was not here for part of the testimony on this case, so I don't have, I have reviewed the videos that are on the portal, but I was not here in those moments. It would be easier for me to address argument in writing if the court's amenable to that. And also, obviously, I would like an opportunity to submit competing proposed findings of fact conclusions along.
Of course. And are you okay with the time, schedule, proposal, counsel?
14 days should be fine, Judge.
Yes, Your Honor, and what we would request is that side by side with that, if we're going to submit proposed findings of fact conclusion law decision, we would also request that the court, or at that time, we would also supply a memorandum of fees and costs concerning the contempt matter itself, side by side with that. So similar to what the court is ordering concerning having an additional line for fees, having an additional line for costs in any proposed findings of fact conclusion of law decision, that you would also have the corresponding fee support for the court's review and entrance for such an order.
That makes sense, Judge. I have no issue with that.
Okay, so let's do that then. And I understand your position, counsel, about not being present, and probably good for all sides to review the video. I know I will have to review prior testimony as well. So that puts us at, it's the last week of January. So let me just make it easy and say, counsels, if you can have everything submitted by January 31st, 5 p.m. It's just a few extra days there. We do have a holiday next Monday. Don't expect you all to work on holiday. And then once I have everything submitted from both sides, we'll formally put the matter under advisement, and I will start preparing the decision.
And Your Honor, I would request then, if everything's going to be due on the 31st, that I will then submit my memo of fees and costs at least a week earlier, so that he'd have an opportunity to object in time, so that you have the full bundle of materials on the 31st rather than later.
Perfect.
I appreciate that, counsel.
Okay, anything else, counsels, for today?
No, Your Honor, I do want to reiterate, and I understand that we're not having a closing argument, but I want to preview what we were going to be requesting. I know that our proposed findings of fact conclusion of law decision included a mix of immediate incarceration time plus a state sentence, but I will alert the court that we are going to be requesting, in addition to that, either entirely an incarceration sentence or a greater or longer incarceration sentence with a state sentence. I want to review with my client first, but that's just in light of the fact that we have not had the opportunity of Mr. in further enunciating, or excuse me, further underscoring the need for this court's swift and bold action in this regard.
Thank you.
I'll weigh in writing, Judge.
Okay. That will conclude this hearing then. Thank you, counsels, for your presentations. I look forward to reviewing your information in a couple of weeks. And good news is, because I only have a few domestic cases, it shouldn't take as long as far as review and getting a decision out.
I appreciate that very much. Thank you, Judge. And final thing, okay? If there is, for the purposes of, because I understand that there's still lingering questions as to why Mr. Is discovery open for the purposes of ascertaining his whereabouts on the 13th and 14th of this month?
Counsel, your position?
I have no issue. I'm going to be looking into it as well.
Okay, thank you, Judge.
It'll be open for both sides.
Thank you, Your Honor.
Anything else?
No, Your Honor.
Alright. That concludes this hearing. Thank you, everyone.
We will submit proposed orders concerning the other matters as well.
Yes, certainly.